Welcome to County Portal, your simple source for local government services and public records. Let's get started.
Determining reasonable compensation for a power of attorney agent is a common and important question. A power of attorney, or POA, grants someone the authority to make decisions for another person, called the principal. This role often involves significant responsibility. Whether a POA agent can even be paid depends first and foremost on the POA document itself. Many POA documents for family members do not mention compensation. If the document is silent, especially for a family member, compensation is often not expected or legally authorized without further agreement. However, some POA documents explicitly state that the agent can be paid. They might even specify an hourly rate or a percentage of the assets managed. If the document allows for compensation but does not state an amount, then the compensation must be reasonable. What is reasonable compensation? This is where several factors come into play. State law can also influence what is considered reasonable. Some states have guidelines or default rules for agent compensation. The complexity of the tasks performed is a major factor. Managing simple bills for a few hours a month is very different from selling property, managing investments, or operating a business. More complex tasks generally justify higher compensation. The time commitment required by the agent is also crucial. Agents should meticulously track all hours spent performing duties on behalf of the principal. This record-keeping is vital for justifying any compensation claimed. The skills and expertise required for the role also matter. If the agent needs specialized knowledge, like accounting or real estate expertise, this can factor into what is reasonable. Another benchmark is what a professional fiduciary, like a professional trustee or guardian, would charge for similar services in your geographic area. These professionals often charge an hourly rate. A reasonable hourly rate for a non-professional agent might be comparable to what a professional would charge for similar administrative tasks, not necessarily for specialized legal or financial advice unless the agent holds those credentials and is performing those specific services. Compensation as a percentage of assets is generally uncommon for a standard POA unless specifically authorized in the document for complex estate administration tasks. The agent must always act in the principal's best interest. Taking excessive compensation is a breach of fiduciary duty and can lead to legal disputes. Transparency is key. If there are other beneficiaries or family members, discussing and agreeing upon compensation upfront can prevent future conflicts. If you are an agent or a principal, and there is any uncertainty about compensation, seeking advice from an attorney specializing in elder law or estate planning is highly recommended. They can help interpret the POA document and relevant state laws. Always keep clear and detailed financial records. This includes all income, expenses, and compensation taken. It protects both the agent and the principal. Thank you for watching this video. We hope this information helps clarify what reasonable compensation for a power of attorney might entail. If you found this helpful, please give this video a thumbs up. Subscribe to our channel for more valuable insights into legal and financial topics. We appreciate your support.